do hope in the course of the coming weeks to take a look at the provisions under the Proceeds of Crime Act with a view to properly understanding what is available under this law in this jurisdiction. And the reason I need to undertake that review for myself is so I can assist with a conversation that I chimed in on yesterday. This in relation to the clamor for an addition to the anti-money laundering legislative architecture of unexplained wealth orders in this jurisdiction. And we need to consider whether, as desirable as this particular order appears, whether in its absence there exists a vacuum, or whether we indeed have, under existing laws in Jamaica, and which laws have not been challenged and struck down in any court, whether we have provisions that are operating and having similar effect to what is now being called for. Because what I find is that it is sometimes fashionable for individuals to join forces with others because the thing sounds good. And if the thing that sounds good is not happening at the moment, there's no examination as to whether what is happening now is actually similar to this thing that is being called for. So I know, for example, based on all the disclosures that have been made, that the Asset Recovery Agency, which is an agency that came as a result of the Proceeds of Crime Act passed in Jamaica, and substantial portions of that law were tested up to the Privy Council in the Bobbitt Smalling and others and the Dawn Satterthwaite case. That particular department, Asset Recovery Agency, is now for the most part cash rich, having hundreds of millions of dollars as a result of forfeiture order granted by the court as a result of the either successful prosecution of defendants who have been designated as having a criminal lifestyle or have benefited from substantial sums of money through criminal conduct. And there has been, therefore, forfeiture orders of properties, motor vehicles, cash held by the Asset Recovery Agency. So much so that in one of his last presentations in Parliament, I recall the Finance Minister indicating to the country that they intend to re-engage, I believe, or to engage some realtors, to have the realtors advertise large numbers of registered property now owned by the Asset Recovery Agency as a result of actions pursued successfully against the beneficiaries of criminal activities in the court. So they want to sell them because the Assets Recovery Agency is spending millions of dollars in terms of maintaining these properties. The faster they can sell, the faster money will be turned over to be used for whatever other lawful purposes have been set out for use of this kind of money. So let it not be said, let it not be correctly said, let it not be communicated and appearing that it is being communicated properly, that there's nothing now in terms of either civil forfeiture or forfeiture which is not quite civil, quasi-civil, quasi-criminal, whatever it is that is taking place, because there are hundreds of millions of Jamaican dollars, thousands of US dollars, large inventory of property that the Assets Recovery Agency is now holding as a result of proper pursuit of proceedings in the court against criminal masterminds. And these laws are not only meant for one particular class of individual, meaning some people are of the view that if an unexplained wealth order is brought on the books constitutionally, then it is the political actors who are to be made the sole subject of prosecution under these unexplained wealth order, whether it's for civil forfeiture or they're going to create some sort of unexplained wealth order where there is a known criminal offense or whatever, and then the civil forfeiture must follow. It will not be unique to a particular class of individuals. It will be to every single person where there are assets, perhaps not only in this jurisdiction, but from what we know, the Financial Investigation Division has always cooperated and worked with the Drug Enforcement Agency, DEA, and other cooperating entities in other countries to get whatever information it desires in its pursuits of. So there's always cooperation with the FID, MOCA, DEA, and whichever other agency. And there's nothing that stops them now from, in fact, I believe they have the ability to request of financial institutions. Let me restate that, because I think with the decision of the Privy Council in a recent matter concerning the Bar Association General Legal Counsel and all of those entities, there are particular groups of individuals, especially lawyers, who have a reporting requirement where there are transactions above a certain quantum. Outside of that and long before that, entities such as financial institutions, accountants, and some individuals who were deemed to be potentially enablers for criminals, knowingly or unknowingly. The current anti-money laundering architecture has caught up, and individuals have a duty to report. And when you report, the crucial entity to which a report has to be made within a certain time, in many instances, is the Financial Investigation Division. So when it gets a particular report, it has at its disposal the Proceeds of Crime Act to go after any individuals, either for civil forfeiture, to investigate criminal lifestyle, and to mount whatever prosecution is necessary, and forfeiture thereafter. So it's not absent from the space that certain actions can be taken against individuals who are not dealing in legitimate ways. So which brings me now to this clamor for the unexplained wealth order, the conversation that I opined on yesterday. Because it is not right for it to appear that there is this coincidence of factors now, i.e., it is only because of the finding of the Integrity Commission in relation to the Prime Minister, why the Minister of National Security is now saying that they're not pushing for unexplained wealth order because there is this particular small hurdle. And I played the excerpts yesterday to tell you that in my hearing, months upon months ago, I came upon this Financial Investigation Division conference where Dr. Chang made a presentation February of 2023, and he explained then that this reverse burden that was in Chapter 3 of the Constitution did not carry over into the Charter of Fundamental Rights and Freedoms, which is now our Bill of Rights, looked at by the court. So when I go back to the Constitution, went back to have a look to say, what exactly is he talking about? So in the old Chapter 3, which is now replaced by the Charter, there was this provision. Every person who is charged with a criminal offense shall be presumed to be innocent until he is proved or has pleaded guilty, provided that nothing contained in or done under the authority of any law shall to be held to be inconsistent with or in contravention of this subsection to the extent that the law in question imposes upon any person charged, as aforesaid, the burden of proving particular facts. So in the old Chapter 3, immediately in the presumption of innocence clause, you had this sort of proviso which allowed the Parliament to pass any law that sort of imposes a burden on an accused to prove particular facts. And this section said it wouldn't be invalidated or it wouldn't be in contravention of the presumption of innocence. When I look at the Charter, the first section has come over in full in identical words in Section 16, subsection 5. Every person charged with a criminal offense shall be proved innocent until he is proven guilty or has pleaded guilty. And they put a full stop as opposed to a colon that was in the old Chapter 3. And having put a full stop, they do not carry over the proviso. So the proviso which allowed the Parliament to bring law reversing the burden or giving a burden to defendants or accused to prove particular facts, that proviso is explicitly written out of the Charter. And this is interesting to me legally because of the processes through which we went to frame the wording of the Charter, the years it took to eventually pass it, and there is a big difference between the old Chapter 3, the presumption of innocence clause, and the Charter. And in interpretation, statutory interpretation, interpretation of constitutional matters, I believe it stands for something. What is that something? Only a matter of time. But I say this because I do not believe that what has been said is empty. Yeah? And it cannot be that we're asking individuals, parliamentarians, ministers to pilot bills. Tools now available for civil recovery where it can be invoked whether or not criminal proceedings have been brought for a criminal offense in connection with the property, or whether the person has been acquitted of the offense. So I recall the reach of this law being particularly long. And not only the reach, the actual effect of it in monetary terms, it has been quite good because of the value now of the assets held by the Assets Recovery Agency. Can we do more? They have been doing more. They've been doing a lot more over the years. When you listen to the presentations from that FID conference of over a year and a half ago, you'll hear how year on year they've multiplied the matters that they have brought or are investigating for money laundering and related criminal offenses, and the volumes in terms of the forfeiture, the quantum now in their care. Yeah, and we owe it to ourselves in a world where coincidences are framed that they're really not coincidences. I believe we owe it to ourselves just to make sure that we are safe in terms of the timeline. We can come to any conclusion we want to thereafter, but we must start on the basis of some indisputable facts. I've been listening to the discussion, I beg your pardon, that Dion has been having on the recipients of the Dr. Barry Wint Memorial Scholarship. In fact, I attended the launch at one of the hotels there on Lady Musgrave Road and spoke to a few of the recipients of this scholarship. We've had a situation over the last however many years where the Public Health Service has seen a yearly depletion in expertise because people, after training here, they go away. You look at the roads that we have now after the last bouts of heavy rain we had. As much as Spark program is supposed to be coming on stream, this 2.5 billion could fix whole heap of pothole, whole heap of police station. But the Ministry of Health decides, I want to help to educate these individuals, and there must be a return to the people of Jamaica who are footing this bill. The return is, you're going to be bonded to the country. You must stay here for a certain time after you've had the education and work within the particular field in which you're studying. Now, my understanding is the moment you say individuals are to be bonded, a bonding policy kicks in. Countries don't operate in isolation of policies, of laws, and so forth. Anything related to money, the Ministry of Finance is the entity that deals with that. So though the scholarship comes from the Ministry of Health, because it has a bonding component, the Ministry of Finance's bonding policy, passed and approved by Cabinet, amended over the years, that has to kick in. My understanding of this bonding policy is, depending on the quantum of the award, if the award is between 300,000 Jamaican and 499,999 Jamaican, then the bonding policy dictates one guarantor is desirable and should be had. If the quantum is 500 to 999, 99.99, or 999, whatever it is, under $1 million, it's two guarantors, and that is how the guarantors issue has come in. I believe this is a very good initiative, and I wish the Ministry of Health had worked it out earlier and better with the Ministry of Finance. On top of that, I think students, we need to realize that there's a reason some of these policies come into place, and that is because so many of those who've gone before you have taken a benefit and not returned. They don't pay their end of the bargain, which is why we're here. But we'll get some answers as to where the policy is. Stay with us. I'm up on time.